Okay, welcome everybody. I see a couple of more people joined us. We've gotten started, and Sam, going back to when we met and I participated in one of your BBB meetings, it was clear to me you care about your craft. And when I reached out to you and said, hey, I have a very active alumni chapter, and my goal is to bring them useful content, and I want to deliver that content from people who care about their craft and people who are willing to share. And the way that conversation happened was very much, Sam, what is that you hear a lot about these days? And we will make sure people know that's what we will deliver on the content today. And so I think everybody who registered today, and thank you everybody for the interest, thought that this particular topic, the employment agreements and separation agreements, especially in this environment, is very interesting. So my big thank you for you to deliver us this content today. Thank you for everybody who's joining us. To the extent you have questions during the session, please put them in the chat box and we'll do our best to cover them. We have some prepared materials, but we don't need to make this overly formal or too rigid of a presentation. And we do want your questions. We want to make sure you get what you came here for. The asterisk that Sam mentioned, I'll give it this time, which obviously we cannot give legal advice on this call, but you're welcome to connect with Sam after this. I'll share his contact information after the session. So with that, Sam, let's get started a little bit, and the must-haves, the things that in your opinion are things that you should definitely make sure you have them, whether you're the employer or the employee when you look at these contracts. And maybe we start with employment agreements.
Perfect. Yeah. So we'll go through this. We'll go through some of the slides. I want to just take a couple seconds to thank Olivia for letting me present today. It's an honor to present in front of everyone. And like I mentioned, I do a fair amount in this space, and so it's fun to kind of talk about something that I'm passionate about and I do a lot of. So I want to definitely thank you for the opportunity. Also, quickly mention the slides. Don't feel like you got to take photos of your screen. I'm happy to show the slides afterwards, so don't hesitate with that. So
thank you.
With that, let me go into the screen share. And all right, so yeah, so we'll be talking both about employment and separation agreements today. Focusing first on employment agreements, you know, the number one question I typically ask a new client that says, you know, I want employment agreements is why? You know, why is it that you want an employment agreement with your employees? And I think generally speaking, employment agreements tend to be an overused device. You know, with your average company, with your average typical employee, really don't need an employment agreement. You need a decent handbook, you need a decent offer letter that explains, you know, start date and reporting structure and compensation. But generally speaking, you know, I only recommend employment agreements that there's something unique that's going on that, you know, requires you or compels you to do this, not requires you, but really has you wanting to do this for some specific reason, whether it's, you know, ensuring employment for a specific period of time, whether it's, you know, guaranteeing the person's severance under certain circumstances, whether there's some sort of complex compensation formula that you want to make sure is documented. You know, those may be opportunities where, you know, you want an employment agreement with your employees, but I always like to start there with the client. Why is it that you're asking for this? And why do we want to do it? And because the flip side, the problem with having too many people on employment agreements is now this agreement sets the policies, right? Now it's going to set vacation and benefits and, you know, all these other things. Well, now if you want to change the policy down the road, are you going to have to change 10, 15, 20 different employment agreements just because you want to change policies? Or, you know, smaller companies tend to do it with their first couple hires. Next thing you know, 3 years down the road, they got 20 people with 20 employment contracts with 20 different terms. And so now keeping everything straight amongst all these different employees is a mess. And so that's why generally, unless it's really with higher level people or some really good reason, I typically recommend holding off on actually even having them.
And Sam, quickly for my own benefit, are these comments specific to California, or are most of your comments today focused on California employment law? I know we have some people from outside San Diego, not exactly sure from where, but
yeah, most of the comments are going to be pretty generic. I'm not going to get too deep into legal issues. A lot of what I'm going to be talking about is practical purposes. There are some things that are specific to California, and I will point that out when that ends up being the case.
Okay, thank you.
Okay. All right. So, what are the key terms that we like to have in an employment agreement? First one, very specifically, is terms. Should you have a specific term or not? Should it be a 1-year term, 3-year term, month to month, or just saying it's going to be indefinite until terminated by either side? And then you're going to cite to some provision at the end that specifies how termination is supposed to happen. The other thing I see companies, I think, mess up frequently, in fact, I was just helping a client with this yesterday, is they gave someone an employment contract with a 1-year term. And then we'll commonly see a contract that says, if that's going to be renewed, one of the sides has to give notice of the renewal more than 30 days from the termination or the expiration date. Well, that's fine if you really have your stuff together and you're going to make sure that those deadlines aren't blown. But what I see more often than not is you're going to have that provision. No one's going to be paying attention to the fact that you're up on the 1-year anniversary. And then the employee's going to keep working there past a year. And now you're not going to have anything governing the terms of that employee's relationship, because now the employment agreement's expired and you haven't replaced it with anything. So what I always recommend is, if you want to do that 1-year term for one reason or another, a couple of things you have to do, right? One is you absolutely have to indicate that at the expiration of that 1-year term, unless it's terminated or there's an agreement for a longer period, it's going to default to a month-to-month arrangement or something else. So at least you know it's going to keep being in effect. And then 2, and this is particularly on the employer side, but really on the employee side as well, is making sure you're defining your outs, right? That's fine if you want to guarantee someone 1 year of employment, but do you really want to do that? Or do you want to say, fine, we'll give you that 1 year, but we can terminate you if you engage in misconduct, if you breach confidentiality, if you fail to perform services, things like that. You have to provide for those outs, because otherwise, as all of us know, all these employees seem like they're amazing when they're in their interview, and within a month or two, we figure out if they are or not. And so you got to make sure that you build in those outs for you, okay? Again, so if you're going to have the term, or whatever the term is going to be, make sure you have provisions in there governing termination, both early termination and notice around termination. So that's a conversation I have with a lot of clients. They'll come to me, and the provision will let the employee terminate on 1 day's notice. And so it's always a conversation I have. Well, do you want more notice than that? How much notice do you need to try to provide for that transition? Now, of course, the employee could always just get up and leave and breach that agreement on the notice provision, but at least having that in there so the employee feels bound to comply with that notice provision, I think is very helpful. So you definitely want to take a look at that, and don't always feel like the notice provisions have to be reciprocal. There's nothing that says that that the employee will have to give you 2 weeks notice, but you only have to give the employee 1 week's notice. That's perfectly lawful. Now, you may not want to do that because you're afraid if it's going to look fair or not, but it's certainly something that you 100% can do if you choose to.
Okay.
And then again, on the termination, making sure you build in some provisions for automatic termination, again, misconduct, breaches of the agreement, things like that, and really give some thought to that. Another thing that we see in these employment agreements is severance, and how much severance you want to provide to the employee. Again, I don't, as a factual matter, have an overarching problem with building in a severance term, but again, this should only be for your highest level, most valued people. If you're going to do it, make sure that you define termination for cause that will allow you to avoid having to pay a severance if the person is terminated for cause. The absolute last thing that you ever want to do is have a situation where you catch someone stealing from you, you fire them, and now you got to pay them 6 months severance. So really make sure that you define in your severance agreement that if the employee is terminated for cause, you don't owe them a penny, okay?
Sam, as a practical matter, in a company that is trying to button up, if you will, their employment agreement or practices, is it a COO? Is it a director of HR? Is it maybe internal counsel? Whose responsibility is to think through these things and maybe engage with outside counsel or do it internally to put all that thinking into the actionable documents?
It's a great question, and there's no clear answer to it, really, because it depends on the company, right? And some companies, you know, a smaller business is going to be the business owner. Once you get a little bit bigger, you know, maybe there's an HR person that's handling it. You get a little bit bigger than that, you know, maybe it goes to the CFO and they're handling it. So it really just depends on the size of the organization and who tends to lead the day-to-day. I mean, I have a client that's one of my longest standing clients. They have a couple hundred employees, but the person that runs HR pretty much runs the entire business. The ownership is, you know, a little bit older. They don't come in every day. She makes all the decisions, you know. Meanwhile, that's pretty rare of a company their size, but with this organization, that's how it is. So it really just depends on the organization. But I mean, for any of you on here that has a lot of employment agreements, you know, I guess my best advice to you, whether it's me or someone else, is, you know, is it time to take a look at what is in place for everyone and making sure it's all jiving, it's all consistent with what you want, and you're getting all the protections that you really want in those agreements. So.
Got it. And Sam, I did tell you the UCLA Anderson audience is not a shy audience. Maybe today is a special day. Just a reminder, everybody, if you do have questions, you can put them in the chat box. I am monitoring it, and we'll try to address them as we go along. And Sam, sorry I interrupted your flow, but thanks for the answer.
No, my pleasure. Okay, so we talked about severance already. Definitely want to set the terms of compensation, what the salary is, what bonuses they're getting. Are they guaranteed bonuses? Are they discretionary bonuses? That, you know, needs to really be spelled out well. And then definitely if there's any sort of commission structure to it, you want to either spell that out in the employment agreement or in a separate commission agreement. In California, if you have a commissioned employee, by law, you have to have a commission agreement with them. I know that we as Californians sometimes get annoyed by Sacramento and the burdens that they put on us. You know, they passed this law requiring employers to have written commission agreements a couple of years ago. And I think this was actually a favor because, you know, there's no better way to get sued than to have a commission structure with an employee and not have it in writing. I mean, that is just an invitation to litigation. So definitely have commission agreements with your people and have good commission agreements. They don't have to be lengthy commission agreements, but make sure that you are dealing with, in my mind, the 4 critical components of the commission, right? When is it earned? How is it earned? When is it paid? And specifying that there's no right to the commission after separation. Those 4 components have to be crystal clear, right? So you really need to define the term earned. That's the critical word in California, really anywhere on commissions. What is it that triggers the earning of the commission? And what I always like to structure it on typically is the client paying? Once the client pays, that triggers your obligation to pay the employee, and then specifying that you're going to pay that commission within X number of days of it being earned. The other thing to be really clear about is if you have commissions, try to base them on gross numbers and not net numbers. The problem with net numbers, and I've litigated this extensively, are two components. One is if they're based on net numbers, the employee always thinks they're getting taken advantage of because they think you're playing fast and loose with the expenses. And then B, if there's ever a dispute about the calculation of the commissions, if you're basing it on net numbers, you have to turn over a wealth of documents to the employee to justify the expenses. So if you can base it on the net numbers, and that way if there's ever an issue, you're going to show them, look, this is exactly what the client paid. It's much easier to resolve issues there. So take a look at that. If you don't have written commission agreements, or if you pulled it from the internet, call your employment lawyer and have him or her update those documents.
I did not know that.
Yeah. Also, again, so this is more specific to California, but a couple things that you cannot have. Can't have any non-competitive language post-separation, right? So during their employment, you can tell people, while you're employed here, you're not going to work with our competitors. That is completely and utterly lawful. You can do that. However, what you can't do is say, you won't compete during your employment and for a period of 2 years thereafter. That may fly in Texas, it may fly in Georgia, but it does not fly in California. So don't even include those provisions. There was also a case out of San Diego about a year and a half ago that dealt with employee non-solicitation provisions. So those are also unenforceable. You cannot have a provision that says, if you leave employment, you agree not to solicit any employees to also leave employment within X number of days of your separation. So I would advise against even including those provisions. Some companies like to include them and just say, well, we won't enforce them on the back end, but we'll put them in there to scare the employee. The problem with doing that is this case that I mentioned from a couple of years ago. It was against AMN Healthcare that sued to enforce one of these provisions. The other company that they sued actually cross-complained against them, saying this provision was enforceable. That company won and was awarded attorney's fees by the court. So it can actually be very costly and backfire to include these provisions. So I recommend against even putting these in here. Olivia, I see there's a couple comments. Anything we want to jump in with?
Yeah, I think it's good. We're getting some engagement here. So to the extent you can answer this, I'm not sure of the specifics, but somebody having such a contract, maybe I imagine with some of those provisions that are not enforceable in California, but they come from a New York firm and they're moving to California. And are these provisions a new thing in California? Maybe we can address this together, and then we'll see about the at will.
Yeah, so generally, the law where the employee performs the services controls. So if the employee is performing the services in New York law is going to apply, and you're probably going to have an employment agreement with them, or something with them dictating that New York is going to govern any disputes. So just because the employee quits and moves to California doesn't mean they can force you to apply California law. One thing that you cannot do in California, and this was another new law that the legislature passed a couple of years ago, is you cannot employ someone in California but tell them that disputes are going to be litigated in Texas under Texas law. That is 100% unenforceable, even if you're a Texas company. If you're employing people to perform services in California, California law has to apply. So don't try to be too cute with that, even if you're a multi-state employer.
Got it. Okay. Are these new things, Sam? These unenforceable provisions, or what the California law calls unenforceable?
Yeah, no, most of these things I've been talking about as far as the employee non-compete is not new. I mean, that's been the law of the land for a while. The employee non-solicitation is new. And this law that I just talked about, saying that you cannot apply a foreign state's law to a California worker, that's about I don't know, about 3 or 4 years old now.
Okay. I'm not sure what the at-will employment question is about. To your knowledge, does this have anything to do with these non-enforceable provisions, at-will employment? If it's unclear, we can...
Yeah, I'm not 100% clear on Tom's question, but I can tell you generally that California, by default, is an at-will state. So, you know, the nails on the chalkboard thing I'll hear from clients sometimes, as well as California, you can't fire anyone. I say that's bogus, right? You need A players, and if they're not A players, you either need to give them the tools they need to become A players, or you get rid of them. So it is at will. You can terminate someone for any reason. You just can't sue them. You can't terminate them for an illegal reason. So, you know, I can employ Olivia and just say, you know, look, I don't like guys with shaved heads. I'm going to fire you because I don't like your shaved head. That's okay. That's lawful. There's no protection in California
for shaved heads.
With shaved heads. I can, you know, someone can wear, you know, ugly shoes, and I can just, those shoes are ugly, you're fired. I can do that. Is it stupid? Yes. Is it, you know, bad business? Yes. Is it perfectly legal? Sure. 100% legal. You just can't, you know, but you can't fire someone for all those protected characteristics we know about: age, gender, sexual orientation, ethnicity, things like that. So hopefully that answered the question. Tom, feel free to, you know, follow up in the chat room if that did not.
Got it. Thank you. And there's a question here about the authority for other states laws not applying not applying to California employees. I'm just gonna maybe make a blanket statement, Sam. I do believe what you're saying and your expertise. I think if somebody wants to maybe get into the nitty-gritty as to, you know, what justifies that view, I would invite them to engage with you. But I think we might spend a little too much time kind of pointing the body of law or where something comes from as far as, you know, what law applies and everything else. Is that fair?
No, I think that's right.
Okay.
All right, so going back to, oh, sorry, hold on. Get back to the screen share here. Okay, so we talked about that. Referencing what employee benefits the person will get. Again, I try to avoid that if I can, because I want to default that back to our handbook, so that way, if we have a change in the benefits, all we have to do is change the handbook and roll out to all the employees the change. If you have, you know, a benefits provision in the employment agreement, I'm going to reimburse you, you know, $400 a month for healthcare. Well, now if you want to change that policy down the road, you got to redraft the agreement, get signatures. It's kind of a pain. So I recommend against including benefits if you can. I would also put in there some provisions about making sure the employee returns property at termination. Okay. And also, unless you're going to have a separate non-disclosure agreement, I put in there some protections around the fact that anything that they create during their employment you own, and that they won't, you know, violate any of your intellectual property rights. So pretty standard provisions, whether it be in employment agreements or handbooks, but just make sure you have those protections. The other question I get a lot is around arbitration provisions in employment agreements. This is another lawyer answer you're going to get as to whether or not arbitration agreements are good, and that answer is it depends. They can be, depending upon the size of the company and what you're trying to avoid. You know, the benefits to arbitration is that, you know, the filing isn't public, so there's not going to be a public record of the filing of the lawsuit. You're going to get an arbitrator, so traditionally, you know, the thought is you're going to avoid some sort of crazy runaway jury verdict because of that. And then the other benefit to them is if you have a real concern around class action claims, class action waivers in arbitration agreements are enforceable in California, so that can be very powerful. The downside to arbitration is it's expensive. So, you know, Superior Court is free. You have a dispute on turning over documents, you have a motion you got to file, you don't have to pay the judge to resolve that issue. You're in arbitration, that arbitrator is going to charge you $5, $6 grand, $7 grand every time you have an issue that has to get resolved. That arbitration hearing, a week-long arbitration hearing, is going to cost you tens of thousands of dollars just in arbitration fees. So what I normally tell people is, really think about what you're trying to avoid. If you're trying to avoid the big wage and hour class action, it may be helpful. But if you have a single plaintiff, minimum wage worker that sues for meal break violations, do you really want to enforce an arbitration provision on a claim that's soaking wet a $20,000, $30,000, $40,000 claim? Probably not. So just be mindful and give some thought to whether or not in your circumstance, arbitration agreements are a good idea or not.
Got it.
I think we had a question there too, right, Olivia?
Yeah, we have a couple, and maybe some of these would apply to separation agreements, maybe not, but one is, if you have employees in multiple states, would you create employment agreements that are specific to that state? And then another question is if you would recommend making a provision to allow for changes in the capital structure, a merger, venture capital being contributed, etc. Any comments on that?
Yeah, so if you have employees in multiple states, I generally recommend having handbooks for each of those states. And you're not going to have totally different employment agreements, but there are probably going to be a couple nuances that you're going to have, even specifically dealing with some of this stuff, right? So in California, a non-compete's not enforceable, but again, if you want to pick Texas, in Texas, as long as it's reasonable in time and geographic scope and scope of business, it is enforceable. So you may want to have a provision like that in a Texas employment agreement that you wouldn't have in a California employment agreement. Same thing with the non-solicitation stuff that we talked about. So there may be reasons to have, minor differences from state to state that you give some thought to. Now, whether change in control or other capital raises should be included, in my mind, that kind of comes up in two components, right? One is, are you going to have some sort of phantom stock issue in the employment agreement that's going to trigger some payout? This presentation is not a phantom stock presentation. I could probably take an hour on that topic. So
sure.
I'm going to punt on that. But I say, unless you have that phantom stock situation, or if you want to tie it to the severance, right? So you could tie it to, look, if there is a change of control or liquidity event, and that acquiring company doesn't bring you on or doesn't employ you for 12 months, you're going to get a severance of X number of months. And so you could think about it in that way. If the employee wants some sort of protection in case that happens, and then the acquiring company terminates their employment. So that's generally where I'll see that issue arise.
Got it. Okay. Thank you. Appreciate everybody's questions, by the way, as well.
Yeah, they're great. Okay, so that was my last slide on employment agreements, and now I was going to talk about some separation agreement stuff. Is that okay?
Yeah, perfect. Yeah.
Okay, perfect. So, big things that we see you want to include in separation agreements, obviously the amount that you're going to pay the employee in severance. And the big issue there is how you're going to pay it. Are you going to pay it in one lump sum, or are you going to pay it over time? In my mind, I generally recommend paying it in one lump sum for a couple of reasons. One is, I don't like multiple payments because it gives multiple opportunities to mess up the payment. And so I just try to avoid that.
Sure.
The only time I recommend it is if you have, let's say, a non-disparagement provision, or you have a provision that says after separation, employee needs to make themselves available for, questions and transition issues for 6 months. In those circumstances, paying out overtime can be beneficial, because that way, if there's a breach, you can stop making the payments, rather than if you've already paid it all up front and now there's a breach. Well, now you got to sit down with your lawyer and say, okay, do I really want to sue over this or not? And is it going to really be worth it to do that? So that's generally the conversation around how to make the payments. No rehire provisions tended to be typical in employment agreements that we'd see. Provision like that says that, you agree that you will not, after separation, you will not be reemployed here. You will not apply for future positions here. And if you do, you understand that this agreement is a basis to not hire you. So you can do that in other states. Those provisions are now also illegal in California and unenforceable in California.
Okay.
So you can't put a no rehire provision unless there has been a validated claim of sexual harassment against that employee, in which case you can, which is really a real tough spot to put yourself in now, right? Because now you're going to have to actually acknowledge that the separated employee engaged in sexual harassment to justify the no rehire provision, which means that the person that accused them of harassment, now, like, you basically just made his or her case that the harassment took place because you've included this no rehire provision. So really, you know, for the most part, I would recommend just removing the no rehire provisions. You know, again, this non-solicitation, non-compete language doesn't fly. And, you know, and because we have a more sophisticated group and a financial group, I'll also say that non-competition agreements are enforceable when it focuses on the sale of a business. And so what some companies try to do is kind of be cute by giving employees a small fraction of the company in order to justify the non-competition provision. And courts will generally strike that down. I mean, the ownership and the sale of business has to be substantial. It can't just be some, you know, more value giving them as a ruse. Yeah. On the release language, just keep in mind that if you're over 40, like probably a fair amount of us are on here, the Age Discrimination in Employment Act applies. So if you're over 40 and you don't feel old, I'm going to make you feel old now because the law actually protects you. So there are some provisions that you have to provide if the person is over 40. After they sign, they get 7 days to, well, once you give them the contract, they have to be provided 21 days to review it and consider it. And then after they sign it, they have to be given 7 days to revoke it. And that revocation period is important because it's going to tie into how you're going to make the severance payment, right? If that person has 7 days to revoke, you're not going to make that severance payment until after that revocation period expires, right? Because heaven forbid you make the payment, then they revoke. Good luck getting your money back from them. So just be mindful of that. You know, another thing on the employer versus the employee side, how to make the release. Is it mutual or is it unilateral? If you're the employee, you want to try to push to make it reciprocal. Generally on the employer side, they'll say, well, hey, you know, we're the one paying you, we're getting the release, but we're not releasing you from anything. Particularly, you know, if the employer is thinking, well, what if we dig in and we find something after the fact that you did that was, you know, illegal or something like that, you know, we want to make sure that we have some protection there.
So you do have a practical consideration of whether or not the employee wants to sign the separation agreement, or both parties, I should say, assuming the company wants to sign it. Can you, and this is just my uninformed question on this, but can you put in the employment provision either separation clauses or a requirement that the employee needs to, I don't know, at least consider the separation agreement, or it's kind of whatever he or she wants to do?
Yeah, you can definitely include in the employment agreement a provision that states that if the employee, if their employment is terminated under certain circumstances, they will get a severance on the condition that they sign the release that they're going to get at the end of the employment. And sometimes companies will provide a generic release in that employment agreement, but that still doesn't mean that the employee has to sign the release or they have to take the severance. They could still terminate and just say, you know, see you later, I don't want the severance, I'm going to sue you instead. So that can certainly happen. And that's the other thing, I mean, to think about, if you're offering that severance as part of the employment agreement, and let's say you're telling them they will get 12 months severance, you know, on the back end when their employment terminates, the little bit of a problem that you have there is now you've created the floor of how much you're going to pay in severance, right? So now they're going to negotiate up from the 12 months because you've already guaranteed them that amount. So if you're going to guarantee, you know, some level of severance at the end of employment, I try to build it in lower if you can, so that way it gives yourself some room to negotiate up to maybe 9 or 12 months rather than starting at 12 and now you're going to negotiate up to 15 or 18. So give some thought to that. There's also typically non-disparagement provisions in severance agreements. One of the things that we'll hear from employees and then employees will ask for is mutuality with that provision as well, so that the employer won't disparage that employee. Typically, the way that gets negotiated is the employer will say, well, look, we can't guarantee what everyone's going to say and what everyone's going to do, but if you want assurances that the C-suite's not going to disparage you, or HR and the owner's not going to disparage you, we'll agree to that. So usually that's where the negotiation turns on that topic. There's usually always a provision about having the employee indicate that they submitted all expense reimbursements. If you are the employee, make sure you have done that. There's typically also confidentiality, that the terms of the settlement agreement are going to be confidential. You're not going to go running around to everyone else telling them that you got a 12-month severance. And so we'll see that typically in these agreements as well. Make sure you comply with that. And then again, similar to expense reimbursements, there'll typically also be a provision around the return of company property, the employee confirming that they have returned everything to the employer. And typically when I represent the employee, that's just a conversation I have of, hey, make sure you've done this. Make sure if, we're in the middle of COVID, you've been working from home, you get everything back to them. If you've been printing stuff out, marketing decks, financial models, things like that, you either shred everything or you send it back to the company. Just be real careful on that. We'll also see provisions in severance agreements that ask the employee to certify that they have not already filed any claims, because the last thing you want to do is have a situation where you get the employee to release you from any future claims, but heaven forbid they've already filed something with the Labor Commissioner's office. They've already filed a complaint of safety violations with OSHA. And so you want their certification that they have not done any of these things at the time that they're signing the release. There's also typically be a non-cooperation clause stating that if there is a lawsuit that alleges class action claims down the road, the employee will not cooperate in those claims. Another thing to keep in mind is what you may want is kind of what I talked about before, is some sort of provision saying that the employee will make themselves available in the future for questions or for issues. When I'm representing the employee, what I'll ask is that the employee get reimbursed some hourly rate for that time. So that's fine if you want us to help, but look, you're going to have to, pay us for that time. We're not going to make ourselves available for 12 months at your whim for an unknown number of hours and not get paid for it.
So I don't know if anybody realized, but my connection reset, so I actually had to leave. I'm glad you were the host, so you didn't kick everybody out. But what I will say is there were 2 questions that were in the chat, and if you wouldn't mind repeating them so that I can ask them. I remember the first one actually, which was, I think based on what you had said earlier on, Sam, you don't have to have an employment agreement, and the offer letter can serve as the document governing your relationship with the employer. I think that's what I understood. So maybe that's one question. If I'm wrong, tell me. And then the second question, and I don't remember who asked it right after that, please share, or maybe you see it in the chat box. I think you're posted publicly.
Yeah, I see one having to do with employees being furloughed.
Yes, that's the one.
Yeah, so great question on furloughs. If you do have an employee on furlough still, I think this would be time to, again, sit down with your employment counsel and figure out what you're going to do with them. There's no problem having employees furloughed, but there is some case law, particularly around California, about like a concept of indefinite furlough. COVID happened in March. We're kind of 6 months out from that at this point. So if you still have employees on a furlough status, it may be time to sit down with your employment counsel and see, do we really want to keep them on furlough, or is it time just to separate that from employment. And, you know, if down the road, you know, we want to hire them back, we'll see if they're available. So I'm not sure if that answered your question. I mean, it's certainly, there's nothing about them being on furlough in and of itself that would require you to have a separation agreement. Now, whether or not it would trigger your obligations under a employment agreement to separate their employment because they've been off for 6 months, I mean, that would just be specific to what the employment agreement provides. So hopefully that answered the question.
Got it. Thank you. By the way, again, appreciate everybody's questions. And we do have a little bit more time left, but I wanted to remind everybody at the end of this, if you want to stick around, meet some fellow professionals, do a little bit of networking, catch up with some other alumni, stick around. At 1 o'clock, we'll have probably 2 breakout room sessions of networking together. So keep that in mind and appreciate the questions still.
Perfect. And then I think we talked about that. The only other thing you're going to want to make sure you have is choice of law and venue. If there are any disputes, making clear that the law of the state that you're in applies, and also that any litigation is going to be venued in whatever county you want. But again, generally that should be the county where the employee is performing the services. And then Olivia, I don't know, I know we had talked about kind of how to do layoffs or furloughs. I know we're kind of close on time here. Do you want me to get into this, or maybe leave this for a different day, or if someone has questions down the road, they can reach out on this topic?
Well, let's see if we have, anybody has questions about that specific aspect that you want Sam to engage in, or do you have other questions? Okay, we have a vote. Todd, thank you.
All right, I'll try to speak quickly, but not too quickly. All right, so yeah, so this was something we got a ton of questions about early in COVID. All the questions were around, how do I lay people off or furlough them? And then once people started getting PPP money or the economy started opening back up a little bit, there were a lot of questions around how to bring people back. There are both California and federal laws called the Warren Act that deal with how to do mass layoffs or mass plant closings that typically govern layoffs of 50 or more. So if you're doing that level of layoff, make sure, again, you talk to your employment lawyer and you make sure you're complying with all the Warren notice requirements. It is very cumbersome, and the penalties for doing it wrong can be extraordinarily large. So do not mess this up. What I've been telling clients, though, is even if you don't have if you don't have more than 50, or you're not doing a layoff of the entire plant, to still follow some of the Warren guidelines. So what Warren requires is, if you're doing this layoff, to do what's called an adverse impact analysis. We are listing out all employees, hire date, date of birth, job category, and any sort of protected statuses, gender, things like that, and look at this to determine whether or not you're imposing these layoffs in some way that's discriminatory, right? And so the concept behind it is, maybe your thought wasn't to discriminate against all of your older workforce, but once you put this all down on paper, you look at it and you're like, holy cow, marketing is 6 people, we're laying off 4, and all of them happen to be over 50 or something like that. So what I've been telling clients to do is to engage in this Warren analysis when either laying off people or when bringing them back, even if the law doesn't require you to do it, because I think it's going to help you in 2 scenarios, right? One is it truly is going to help you see if there's something going on with this layoff that just doesn't feel right, that looks like you're targeting all the women or all the older people, or whatever the protected class may be. And then 2, I think it's going to be very helpful in the event you get a demand letter from a plaintiff down the road that claims that you did this in a discriminatory way. You have Exhibit A in defense of your lawsuit, showing them that, you know, not only were you not discriminatory, but that you took the time to sit down and engage in this analysis to make sure that you were doing it in a way that was legally compliant. So I think it's a great thing to do. I think that, you know, typically, unless you're laying off thousands of people, it doesn't even take as much time as you think to do it, and it'll provide, you know, I think it'll provide the protections that make it well worth it. So this is one that a client of mine did, just to give you an example. They had, you know, the left blackout is the employee's name, at the start date, their gender, their age, their ethnic classification, and then they've broken it down into what team they're in. They have a notes section where you can put, you know, this person just told us she's pregnant. This guy just told us that he has some medical issue and needs time off, you know, whatever. And then again, when you'll see, once you have that snapshot, you know, does it look like I'm keeping all the white people and getting rid of all the minorities? You know, does it look like I'm getting rid of all the older workers? So I really recommend, you know, looking at things that way. And then just briefly, I mean, also keep in mind there's other ways to reduce your overhead and things that you can do and that are lawful. I get these questions from people all the time. Well, can I, you know, reduce hours? Yes, you're going to 100% reduce hours. Can you reduce compensation? You know, yes, you're going to 100% reduce compensation. Now, are there, you know, morale issues that are going to go along with that? Probably. Also keep in mind, if you have salaried people, to fit into a salary classification in California, you have to earn twice the minimum wage, which is just under $50,000. So don't reduce their hours or their compensation so much that you drop them below that threshold to earn a salary. And then what I always tell people is, you know, a lot of times as business owners or as C-level people, we think we have to be uniform, we have to be equal, and treat everyone exactly the same on these things. And you know, while that is sometimes the safest way to do it, you know, just keep in mind that you want to do these things in a way that, you know, we're retaining and rewarding our A players. And so if we're going to lose people, we're going to lose the B's and C's, you know. So if you're reducing comp, would it be great to reduce everyone's comp by 10%? You know, yeah, that's definitely the most, you know, egalitarian way to handle it. But are you going to lose your 3 best people because you did that? And you're going to be left with your 3 worst people because they're okay with it, because they know they stink and it's going to be harder for them to find a job. So, you know, just be thoughtful about how you're going to roll things out to make sure you're keeping your best people.
Right. Okay.
So yeah, I think I got it done right before noon. 2 minutes to spare.
Well, that was awesome, and we did cover a lot of ground. Andrew, thank you. I think that's a clap. It's not a hand raised, I believe. So thank you. I'm not even sure. Yes, thank you.
When I'm not getting that many questions, I'm just not sure if people, if I'm going too fast, people aren't paying attention. There's like so many things that could be going on.
Well, we did get a fair number of questions, and that was great to see. I think it's safe at this point to say, Sam, thank you. Again, encourage everybody to engage with Sam directly. I'll send his contact information. And to the extent you want to unmute yourself, maybe even turn your video camera on and stick around for our networking session. I see some thanks from people who attended, so that's awesome. I certainly learned a lot. I went through a few hiring steps in my own life as both employer and employee, and I must admit I never really thought that deeply about whether to have the agreement and what goes into it. So I certainly learned a lot, and I appreciate you sharing so openly all this important information.
I appreciate it.
So we got a few more thank yous. And I'm just going to wait a couple more moments to make sure whoever is still on is interested in networking, only so that I can share, put everybody in their own breakout rooms. I'm going to stop the recording now.